Straight ahead on Law and Crime Daily.
This wasn't a bad decision. This wasn't a drug deal gone wrong. This was 3 independent decisions he made to kill.
Will the so-called Daytona Beach serial killer be given the death penalty? And just days before a deadline to be deposed, former President Donald Trump pushes back with a legal appeal. Plus, will the accused Michigan high school shooter be transferred to a children's facility?
Certainly should compel Your Honor to be very concerned about placing this defendant in a relatively less secure setting, which mirrors in so many ways the scene of his original crime.
But first, defendant Brett Hankison takes the stand in the death of Breonna Taylor case.
I knew they were trying to get to him. And it appeared to me that they were being executed with this rifle.
Law and Crime Daily, covering court cases from coast to coast. Welcome, everybody, to Law and Crime Daily. I'm Jesse Weber in for Brian Buckmeyer, who's in Kentucky following the death of Breonna Taylor Case. With me here in New York, as always, is co-host Terry Austin. The defense rests its case after defendant and ex-Louisville police officer Brett Hankison takes the stand for hours, detailing the moments that led up to the deadly shooting of Breonna Taylor. Hankison is not charged in Taylor's death, but instead stands trial on charges of wanton endangerment for firing shots into Taylor's apartment that went through the wall into the neighboring unit. Hankison was one of 3 officers involved in a no-knock drug raid performed on Taylor's apartment in March of 2020. Believing the officers were intruders, Taylor's boyfriend, Kenneth Walker, fired at them. The officers shot back, and Taylor was killed in that crossfire. Former officer John Mattingly was also shot. Officials say ex-officer Miles Cosgrave fired the deadly shots that killed Taylor. On Wednesday, Hankison took the stand in his own defense, and he told jurors what led up to the shooting and later the conversation that he had with Kenneth Walker.
I knew Sergeant, I knew Sergeant Mattingly was down, and I knew they were trying to get to him. And it appeared to me that they were being executed with this rifle.
So what did you do?
I returned fire through the sliding glass door. He wanted to know what was going on. I said, "You shot the police." And he said, "I did not shoot the police." And I said, "Well, who did?" And he said, "My girlfriend." And he said, "She shot you with her 9. And I said, "Well, where is she at?" Because I had no idea there was another person inside at all. And he said, "She's dead inside."
And what did you do then?
That kind of shook me because, there was only supposed to be one person in that apartment, and now there was allegedly a girl dead inside, and that wasn't why we were there.
Our own Brian Buckmeyer was in the courtroom for Hankison's testimony, and he joins us now live at the Jefferson County Courthouse in Louisville, Kentucky. Brian, it's good to see you. We heard Hankison's direct examination. The question is, how did he do on cross?
Yeah, he did fairly well, I would say, Jesse. Now, the prosecution in their cross-examination pushed Brett Hankison in terms of what he could and couldn't see the night that warrant was executed. Now, Hankison described how he interpreted an active threat. He said he could tell there were different guns being used in the shootout based on the sound alone. But we know from reports that Walker only shot once. Hankison also said that he was absolutely sure he wasn't firing at his fellow officers when he shot through the window, even though he couldn't see them. At times, it seemed like Hankison may have been a little nervous, wiping his brow and fanning his jacket for air, but to be fair, it is warm in the court. Prosecutor Whalen tried to, but didn't seem to get it out, that Hankison can see the other apartment doors on the first floor, suggesting he could have known about the other potential victims in firing into Breonna Taylor's apartment. Finally, prosecution ended with, and there is no policy in the LMPD for giving suppression fire. However, the prosecution didn't really follow up on that point in cross-examination, but we expect her to go deeper into that on closing arguments Thursday morning.
All right, let's talk about this a little bit. So I'm joined, of course, by co-host Terry Austin, but also legal analyst Kirk Nurmi. Kirk, it's good to see you. I want to start with you. We saw testimony of Hankison breaking down on the stand. You know what I'm going to ask you? You think it was real or manufactured?
You know, Jesse, I think we see the witness stand over and over again as a really emotional place. We see a lot of emotional breakdowns. And keep in mind, Jesse, this testimony brought Mr. Hankison back to emotional time. Whatever we think of what he did, he witnessed his friend, his partner, someone he cared about deeply, who rushed to the hospital to check on after the incident was over, get shot, and concerned that he might be actually killed by this gunman who he didn't know at the time was behind this door. So ultimately, Jesse, I think that the tears, I have every reason to believe those tears were genuine, they were authentic, and they came from that emotional place that we often see people get to on the witness stand.
And just to play devil's advocate, they did come at opportune times in his testimony. And I want to bring you now to Terry, the cross-examination. What did you think? Did the prosecution make any key points there?
Well, I think the Commonwealth did a terrible job. Honestly, Barbara Whaley spent so much time on questions that really weren't that relevant, and she didn't make any points. For instance, she kept trying to say that he was trained, and so, okay, yes, he was, but then she had him read letters of accommodation, which frankly only made him look better as far as I'm concerned. Then she was trying to say that he was backing out and basically that he left his partners to be killed. Well, I think he established very well that he was backing out because he wanted to make sure that he moved so he could address that threat. And frankly, overall, his demeanor, I think he was cool, calm, and collected. And I thought his tears were real, frankly. And last thing I'll say about Barbara is he was rude at times, and there wasn't any need to be rude. And I think that's going to hurt her case at the end of the day.
Well, Brian, I'll let you round it out. You were watching it. Were there any points that stood out to you on direct, cross, and maybe how did the jury react to certain points during his testimony?
So the jury is definitely a mixed bag. You can tell that many people were paying attention. Some people kind of often looking to the side, but everyone was awake this time. It wasn't like the Cosgrove deposition. But I think in terms of this case, both in direct and cross-examination, it looked like both sides maybe brought up good points, but didn't really hammer them home in a way that I think would have been more powerful for the jury. And it really looks at this point, I think it could go either way. I think this case is going to be ultimately decided with the summation. Looking at some of the charging conferences, though, it looks like it may lean a little bit more to the prosecution in terms of what defenses will be brought to the jury. Right. But I think at this point, the defense may have a strong case.
Like I say with so many of our cases, we will wait and see. Brian Buckmeyer, excellent reporting as always. Thank you so much. Still ahead on Law&Crime Daily, will the 15-year-old accused Oxford high school shooter be moved to a children's facility? But first, former President Donald Trump files an appeal to block judge-ordered depositions. That's ahead on Law&Crime Daily.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTube TV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTube TV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTube TV. We put you in the jury box.
And welcome back, everybody. Former President Donald Trump pushes back at a New York judge's ruling by filing an appeal to avoid court-ordered depositions. This appeal comes just days before a March 10th deadline for Trump and his children Ivanka Trump and Donald Trump Jr. to provide statements under oath. This comes as New York Attorney General Letitia James spearheads a civil investigation into the financial dealings of the Trump Organization. James is investigating whether Trump misled investors or insurers with business financial statements. Trump's attorneys argue that AG James should bring the family before a state grand jury investigating the Trump Organization if she wants to hear their testimony. And all this comes just 1 week after the resignation of 2 New York City prosecutors who were leading a separate Manhattan District Attorney's Office investigation into Trump's business practices. So clearly a lot to talk about. Kirk, I jump back to you. What do you think Letitia James is trying to find out by deposing the Trump family? What do you think that's going to add to her investigation?
You know, Jesse, I think a probable defense to charges like this with financial documents, what have you, is that, you know, the defense would be they're relying on the professionalism of the attorneys, the accountants, everyone that was involved in the preparation of these documents. I think what Ms. James might be looking for is kind of the intent and knowledge How involved was the Trump family, the former President Trump, his daughter? How involved were they in the preparation of these statements? What statements went over? How involved were they? Were there any fraudulent things done on their behalf to mislead their accountants, what have you? So I think that's kind of the line of exploration she's going down to cut off any possible defenses, and of course, see if they contradict anything that she already knows to be true.
So as Kirk said, there's a lot to gain from James, but a lot to lose for the Trump family, right, Terry? And I'm curious, attempts to avoid this, the strategy they've been invoking right now, is it effective? Is it working?
I actually think it is effective. Look, he's done it before. He did it when he was being impeached. Those proceedings were delayed. He either denied, he deflected. And at the end of the day, those types of tactics seem to work for him, and it's working right now. He waited until the last minute to appeal the decision, which really basically gives him more time. He has every right to do that. He's arguing that these depositions shouldn't proceed because of the, criminal suit. But listen, I think the longer he takes to delay these, the better it is for him. And one of the things the judge said is, look, you can sit for these depositions, but you can always take the fifth. And in fact, that's what Eric Trump did when he was deposed.
Yeah, I agree. So if he ends up sitting or his children end up sitting, that's maybe what the testimony might end up being. But at the very least, they're trying to avoid it for now. Coming up on Law&Crime Daily, the penalty phase continues for the convicted Daytona Beach serial killer. Plus, the deadly Oxford High School shooting, where a Michigan judge rules accused shooter Ethan Crumbley will be held until trial. And welcome back, everybody. Legislation which would make lynching a federal hate crime passes by a landslide vote in the U.S. House with only 3 votes against it. It's called the Emmett Till Anti-Lynching Act, named after the infamous 14-year-old black teenager who in 1955 was kidnapped, tortured, and shot in the head after allegedly whistling at a white woman at a Mississippi store. The woman's husband and brother-in-law were tried and acquitted for his murder by an all-white jury. The two later confessed to actually killing him. And that woman, Carolyn Bryant, more than 50 years later, confessed to lying about Till hitting on her in the very first place. Under the law, a crime could be prosecuted as a lynching if someone is killed or hurt during a hate crime. Lawmakers have failed to pass anti-lynching bills more than 200 times in the last 120 years. Lawmakers are encouraging the Senate to take up the legislation if passed there, and then it will head to the president's desk. Switching now to Michigan, where a judge denies the request to move the accused Oxford High School shooter to a juvenile facility after a compelling argument by the prosecution.
The sampling of text messages you've been provided between defendant and his friend date back to February of 2021, and they reveal much about the defendant and certainly should compel your honor to be very concerned about placing this defendant in a relatively less secure setting with juveniles, and certainly one which mirrors in so many ways the scene of his original crime.
On Tuesday, Judge Kwame Rowe ruled Crumbley will remain in the Oakland County Jail for Adults, saying, quote, "It is clear that Children's Villages is incapable of safely housing the defendant," citing 8 escapes from the Children's Village in the last month. Judge Rowe also referenced items of grave concern in Crumbley's journal, saying Crumbley, quote, "noted he killed 8 infant baby birds by slowly torturing them until death." Crumbley faces multiple charges, including terrorism causing death, first-degree murder, and assault with intent to murder for the Oxford High School shooting in November of last year. Officials say Crumbley opened fire at the school, killing 4 students and injuring 8 others. Prosecutors say his parents, Jennifer and James Crumbley, ignored warning signs leading up to the shooting, and they now face 4 counts of involuntary manslaughter. A review hearing on Ethan Crumbley's placement is slated for March 24th. So, Kirk, Crumbley's defense attorneys are saying that he's being held in, quote, extreme isolation at the adult county jail. They're saying it's causing more harm than good to their client's mental health. Is that an argument that's eventually going to hold up?
I don't think so. Now, Jesse, there's no doubt about the fact that Mr. Crumbley has severe mental health problems that are probably exacerbated by the solitary confinement. But really, there are no alternatives, right? I mean, when we talk about moving him to a juvenile facility that's had 8 escapes and is, as the prosecutor said in eerily accurate fashion, that it would be like the setting of his crime, that is just simply unacceptable and would be tone deaf to those same problems that led to this crime. Likewise, obviously, he could not be in a general population. So given all that, I don't think that argument is ever going to hold water, and that he is where he's going to be now. And if that results in mental health consequences, they will have to medicate and work their way out of that from that point in time. But right now, I don't see his confinement ever changing before trial.
But Terry, should there be alternatives? I mean, do you think there should be additional holding options other than a children's village or the adult county jail for someone like in his position?
Absolutely, no doubt about it, Jesse. I think that neither facility is ideal if, in fact, the Children's Village isn't secure enough. And we know it isn't because, as Kurt just mentioned, there are all of these individuals who have escaped. Then the adult facility is not ideal because he should not have to be in isolation. And there is the chance that his mental illness is only going to be exacerbated if he is in that condition. And so I think there should be some other place where children in particular who have mental illness can be housed and they can be protected and they can be assisted. So right now we don't have that, but it's something we absolutely need.
Sad case all around. When we come back, will a convicted killer be sentenced to death or receive life in prison? Attorneys make their final pleas to jurors in the penalty phase of the Florida case of serial killer Robert Hayes. When we return. Welcome back to Law&Crime Daily. We head south now to Florida as the prosecution and defense present their closing arguments as part of the penalty phase in the case of convicted serial killer Robert Hayes. Last week, a jury found Hayes guilty of 3 counts of first-degree murder for killing Laquita Gunther, Julie Green, and Awana Patton in Daytona Beach in late 2005 and early 2006. This was a cold case which nearly took 15 years to solve. Hayes was convicted with their murders after a 4th woman, Rachel Bay, was killed in West Palm Beach in 2016. Hayes' DNA was linked to the 3 deaths, and he was arrested in 2019. Now he faces a separate trial in Bay's death. For the penalty phase of the first 3 murders, several people have given testimony before the jury who will ultimately decide if Hayes should be sentenced to life in prison or the death penalty. On Wednesday, prosecutors told jurors that Hayes killing not 1 but 3 people shows his true character.
If you kill someone before, then that is a lot of weight. Think about that. If somebody is willing to kill Miss Gunther, acquire a gun, and shoot her and leave her in an alley, and walk away, and come back 2 to 3 weeks later, and that same individual kills someone else. He shoots Miss Green in the head. So after he kills Miss Gunther, Miss Green, then 6 weeks later, after he's already killed 2 people, ended 2 human lives, what does he do? He makes a conscious choice, he makes a decision, and he decides he's going to end somebody else's life. He's going to kill another person. This wasn't a bad decision. This wasn't a drug deal gone wrong. This was 3 independent decisions he made to kill.
Well, Hayes' defense attorney made a plea to the jury asking them to sentence him to life in prison instead of the death penalty.
Prison without parole is forever. You're not going to hear any jury instruction that says they're going to get out or get pardoned or anything like that. If you sentence Mr. Hayes to life in prison forever, you will be sparing his life. But you're also assuring that he will be locked up and spend his last moment in prison. All life is important. All life is valuable, including the 3 lives that were taken in these homicides. All I can say is all lives matter, and the point now for you to decide is whether Mr. Hayes gets executed or goes to prison without parole forever.
All right, Kirk, what do you think? You think the prosecution sufficiently demonstrated aggravating factors that outweigh any kind of mitigating circumstances here? You think the death penalty is going to be imposed?
Yeah, Jesse, ultimately, when my experience with the death penalty has taught me that when you have multiple victims and you have a lengthy criminal history as Mr. Hayes has, you have more than enough in order for the death penalty to come forward. And we've heard some mitigation, but given those aggravating factors I've talked about, along with the cold, calculated nature of this, the serial killer-esque nature of this, I think it's more than enough for the state to get the conviction they want, get the sentence they want, and I think ultimately sometime soon we will see Mr. Hayes being sentenced to death.
Well, Terry, you know, there was evidence about his mental health. There was evidence a little bit about his upbringing. Let me ask you this. If the jury recommends death, couldn't the judge be persuaded to overrule the jury's decision and impose life in prison? I think we've seen that happen before. Could that happen here?
It could happen here. It's a distinct possibility. You know, there are only 27 states with the death penalty. Obviously, Florida is one of them. But if the jury recommends death, the judge really actually could say, look, I think that the mitigating factors outweigh the aggravating factors here. The judge is supposed to give great weight to what the jury is recommending, but he could say that these 45 mitigating circumstances that the defense said really were circumstances that could outweigh those two aggravating factors, the prior murders and the calculated, cold, premeditated nature of this case. So I think the death penalty will probably stand, but the judge does have the right to say that these mitigating factors overruled. And frankly, these mitigating factors, there were so many of them, I really didn't think that they were enough. But the judge could say, particularly that mental illness is something that would make him say, no, there should be no death, that this should be life without parole.
And even though you have a death-qualified jury, this decision is always unpredictable. So like I said, we'll wait and see. Kirk, Terry, thank you so much. Everyone out there, thanks for joining us here on Law and Crime Daily. We're going to see you next time as we discuss justice in America. We'll see you then.